Today we're going to be talking about the measurement period safe harbor and how we use that to determine eligibility. So we're going to go through those rules in particular. So again, I will be checking the question box periodically to see if anybody has any questions about the topics as we go through them. Again, I want to remind everyone that we are recording these webinars, and they are available on MedBen's YouTube page. And so if you haven't been able to access those, please give us a call and we can get you the links to those, the previous webinars. I think it takes about 2 days for each webinar to get up on the website, so this will be available presumably by the beginning of next week. When we talk about the look-back measurement period, we're really talking about this because of the employer shared responsibility penalties. We talked about those a few weeks ago, and the penalties, the employer shared responsibility portion of the Affordable Care Act brought into light, obviously, which employers had to offer coverage, and if they did offer coverage, who they had to offer coverage to in order to avoid paying what we've called the greater penalty, or even the lesser penalty with regards to affordability and minimum value. So what we're really talking about with regards to those penalties is how we are measuring the hours of service worked by any employee to determine whether or not we have to cover them. And that's where the measurement period safe harbor came into being. It came into being with the employer shared responsibility penalties in the same regulation, giving employers a way to count employee hours of service under the Affordable Care Act in order, again, to determine whether or not there were any penalties due. So that was sort of how we got to this place. As we start talking about this, it's important to define some terms that we're going to use throughout this this webinar. And when we start talking about employees and full-time employees under the Affordable Care Act, we really have to think about full-time employees using a new definition. For every other employment purpose, you know, under the sun, whether it's FMLA or COBRA or any other employment purpose, we aren't going to change how we define full-time employee. But this change of definition is important and applicable only to healthcare reform and these rules with regards to the penalties and the rules with regards to offering coverage to certain employees. So now in the new healthcare reform world, we have a full-time employee defined as any employee who works 30 or more hours a week on average. And that is truly any employee. It isn't any permanent employee or just any temporary employee or any salaried employee or any regular employee. It's any employee. So all of those categories of employee, temporary, permanent, regular, collectively bargained, management, any employee, common law employee who works for an employer for 30 or more hours a week on average is now considered full-time for health plan purposes. That new full-time employee is one that's been employed for less than one full SMP, which is a standard measurement period, and we'll talk about the measurement periods in a little bit. A standard measurement period has one definition for the standard way to count eligibility and one definition for the look-back measurement period. So we'll talk about that as well. But when we look at those periods of time when we're counting hours of service, it's a period of time in which someone's reasonably expected to work 30 hours or more per week on average. In contrast to a full-time employee now, we have what's called a variable hour employee. So while a full-time employee is any employee that works 30 or more hours a week, a variable hour employee is one that works any other schedule. So an employee that works less than 30 hours a week, or an employee whose job is, by the nature of the job, the employer is unable to determine if on average they're going to work 30 or more hours a week. So a full-time employee is anybody that works 30 hours or more, and a variable hour employee is everybody else. And so when we go through the examples, when we talk about the measurement periods, you need to sort of bear these two definitions in mind. When we talk specifically about the look-back measurement period, which is what is causing the most confusion with regards to eligibility under healthcare reform in this particular rule, we really talk about a few different measurement periods. First is the standard measurement period, and that's the measurement period that you as an employer, if you choose to use this safe harbor, the look-back measurement safe harbor, is the period you're going to use to define full-time status for the comparable or, sort of adjacent standard stability period. So the measurement period is when you're going to look to count hours of service, and the standard stability period is the period of time that you're going to cover the employees that fall into full-time status during the measurement period. And we're going to go over some specific examples to make that clear. But I wanted you to know at the outset what these two definitions are. One thing to bear in mind, now that we have the delay, and the enforcement delay, the initial rule that the look-back measurement period, the first standard measurement period, could be anywhere from 3 to 12 months with a 6 to 12-month stability period, meaning you could have a 3-month look-back and a 6-month stability period, is sort of off the table now. In general, with the rules in place, the standard measurement period or the look-back measurement period has to be the same amount of time as the stability or coverage period going forward. We had a discrepancy in those rules where we could have a shorter measurement period and a longer stability period in that first year because the rules came into effect in the middle of 2013. So when Congress or the tri-agencies were putting rules together, they said, well, companies didn't have the full year to comprehend or plan for a full year's worth of a look-back period, so you can have anywhere from a 3 to 12-month look-back period and still have a 12-month stability period in 2014. I'm uncertain whether or not that sort of transition relief will be available when the enforcement delay is removed in 2015. In fact, I suspect that the government will anticipate that in 2014 you will in advance anticipate how long that measurement period will be in 2014, and you will have to have a stability period that equals it in 2015. So the 2014 measurement period will have to equal the stability period in 2015. So bear that in mind. While we had some leverage this first year, 13 going into 14, with the delay, I don't think that transition relief will continue. There are also a couple other sort of periods we need to understand before we get into the particulars. First is the administrative period, and this is a small period of time that slips in between the measurement period and the stability period. So it goes in between the time period that you're used to actually counting hours of service on your employees and the time period where you're giving people coverage, and it is supposed to be a period of time where you actually do the math. You have an administrative period where you stop counting and you add everybody's hours up and you determine who is actually a full-time employee and who's a variable hour employee, who's going to get coverage and who isn't in the stability period. That administrative period cannot lengthen or reduce either the measurement period or the stability period. It really slips in between the two, and it can't be more than 90 days. And so as an employer, if you're going to use the look-back measurement safe harbor, you look at that 90 days and pick an amount of time. You know, it can be as short as a week. It can be as long as 90 days based on your open enrollment strategy, when you can make decisions with regards to your plan, how soon you want to have those decisions made before the stability or coverage period starts. So bear in mind, and we'll talk a little bit about the administrative period when we get to some examples. Then there's something called the initial measurement period, and this is a period where, as when we talk about the standard measurement period and the standard stability period, those are periods of time where you're looking at collective groups of employees that you already have hired. An initial measurement period is a period of time I call it a new employee measurement period because that's really what it is. You hire someone and you have a period of time in which you can count their hours given certain circumstances to determine if they're going to be full-time or not, and it's specific to just that new hire at the time of hire. And so we'll talk about that as well. I'm going to check here to see if I have any questions. Not seeing any in. We'll get right into it. Again, I just wanted to define some of these terms up front as we move forward. So when we look at the shared responsibility rules and the application of the penalties, if you recall, as an employer, if you have more than 50 employees, you have to offer coverage to all of your 30-hour employees, all employees that work 30 or more hours per week. And so, again, the challenge was, how as an employer do I know who these employees are that I'm supposed to cover at 30 hours? And as opposed to just using a definition that said anybody who works 30 hours is eligible for coverage, the law, the actual employer shared responsibility regulations state that the way you're supposed to cover, you're supposed to count eligible employees is on a month-by-month basis. So the standard or the statutory primary method for counting employees is month to month to month. Then there's the alternative that is proposed, and you'll see why here in a minute, by the regulations that allows you to use this look-back measurement period. Either of those options are available to you as an employer to count your employees. Only those two options are available, however. The way we standardly counted employees by definition or by job category goes away. We need to count employees now by one of these two methods. And the month-by-month is the primary statutory method, and the look-back measurement period is the safe harbor or alternative method proposed by the regulations. And both of them have pros and cons, and you'll need to look at them based on your workforce, how your employees are structured, how you hire new employees, and what your philosophy is for coverage as an employer. So let's look first at the month-by-month rule, or the statutory method that was this primary in the regulation. And that primary method is one where you actually count employees on a month-by-month basis. It's very unpractical if you're an employer that has a large variable hour employee population. The method is required unless, again, you use the look-back measurement period. And because you are determining eligibility for each month as opposed to for an entire year or by job category or in some other, let's face it, more practical approach, counting on a month-by-month basis could cause continuing problems for you if you have stop-loss coverage, because people will come in and out of coverage every month. And it could cause treatment continuity problems as well for both fully insured and self-funded plans. When you look at the month-by-month method, really what you're doing is you're tracking eligibility every single month. And what the law says you are supposed to do is you are going to be looking at your employee population and anticipating their moves from part-time to full-time status in the next month, and then either covering those people if they are still or become 30 or more hour employees, or terminating their coverage if they are no longer a full-time 30-hour employee. So if I have a population that has variable hour schedules, one week somebody works 25 hours a week, the next week they work 35 hours a week. I average those up by month, and if 1 month I'm up over 30 hours, I'm on the plan. The next month I'm under 30 hours, I'm off the plan. You can see how that causes some continuity issues if somebody has a long-term treatment plan or has, you know, a chronic illness. 1 month they're covered, the next month they're not. That is highly impractical and doesn't suit many employers' needs. Now, if you're an employer who has a steady workforce, or by the nature of your positions, you only have employees who work more than 30 hours a week. MedBen is a good example. We have 167 employees. all but one of them work well over 30 hours a week. We work a 37.5-hour work week. We're always going to average over 30 hours a week or not be employed. I mean, we just don't have a job where there is a variable hour or variable schedules. So I could use the month-by-month method and not have to worry about people coming on and off the plan. But if I had variable hour schedules or a lot of employee hours that are averaging above and below 30 hours and I don't know who to cover, I'm going to want to move to the look-back measurement period. I'm going to want to use the safe harbor that the government has put into place. And while it was, kind of screwy that they put the month-to-month rule in the regulation to begin with, it's kind of nice that they gave us a safe harbor. The safe harbor has its own issues. It has its own complications. And I've talked with some of you specifically about some of the issues already. But let's sort of go through the rule and we'll look at some examples. The month-to-month rule is pretty straightforward. It is as we have described it. The look-back measurement period and the use of the safe harbor is a little more complicated, and so we have examples that we've put in place to describe that. So again, this method isn't required. You do not have to use this look-back measurement period. It's an optional tracking method which helps eliminate some of the ups and downs with regards to variable hour employees. And again, a variable hour employee is anyone that works less than 30 hours on average or someone who works a schedule that puts them below and above 30 on a regular basis. For this method, an employer chooses a look-back period, or the period they're going to measure the hours of service for their employees. And that period can be anywhere from 3 months to 12 months. And that's what you're going to do as you start to determine whether or not you want to use this method. But I will caution you, now as we talked about earlier, going forward, the look-back measurement period and the stability period, or the period of time that you're actually covering employees, have to be equal. So what happens is you have a look-back period where you count hours, and that same number of months, the same period of time, you need to cover the people that are that become eligible based on the look-back. Those employees are locked in at either their full-time status or a non-full-time status for the entire stability period or look-forward coverage period, even if their job and their hours change. And we'll talk a little bit more about that as well. So again, those periods of time have to match each other. So an employee is identified as variable or non-full-time during the look-back period. They're still going to be treated as variable or non-full-time during the stability period, even if during the stability period they start to work more hours or their average goes up. There is one caveat to that, and we'll talk about that in a minute. But similarly, if during the look-back measurement period the person is identified as a full-time person, their average over that entire measurement period gets them up over 30, then they're covered for the entire stability period, even if their hours drop below 30 during the stability period. Again, a cautionary tale, if you're self-funded and you have stop loss, I strongly suggest that you use a look-back measurement period of an entire year and a stability period of an entire year, particularly the year that you have stop loss coverage, so that those years sync up. If you were to use a shorter period of time, say a 6-month look back and a 6-month stability period, the 6-month stability period would come to an end, the end of the first stability period, in the middle of a stop loss contract year, and that means eligibility could change significantly. Most stop loss policies have a provision in them that states that if eligibility changes by more than 10%, they have the right to re-rate the policy. And you certainly don't want that to happen to you in the middle of a stop loss year. So, so again, if you are a self-funded plan, I suggest looking at a full year's measurement period and stability period if you choose to use the safe harbor. The measurement, stability, administrative periods all sort of need to be uniform in length with regards to different categories of employees. So you could, if you decide to use the look-back measurement periods, you could have different look-back periods for different types of employees as long as they were uniform in length for those categories of employees. So if you have different collective bargaining units that you want to apply a different look-back measurement period to, you could do that. You could have one for salaried versus hourly employees. If you have employees in different states and different circumstances apply to those employees, you could use different measurement periods for those employees as well. But again, you want to make sure that those are uniformly applied across all of the categories. And the statute is very clear that you can vary the categories by these different types of employee classes. Okay, so let's look at some examples. We're going to talk first about a current workforce, what the regulations and the statute call ongoing employees, and we're going to forget about new hires for a moment. We're just going to look at a current population. So in this event, this is the January 2014 plan year. We're going to use a January 2014 plan year start as our example. A measurement period could be any time during the year. If you're a June 1 group, you can measure back from June, 3 to 12 months, depending on your particular circumstance. And the measurement period then is that period of time that you're going to measure the employees. In this particular example, we've used a, I don't know exactly if that was supposed to be a 9-month look back and a 3-month admin period, but this total period of time is 12 months. So we've got look back period here. This is where we're going to measure the hours worked of all of our employees and average them together over the weeks worked in the measurement period, and we'll come up with a number. And a certain number of employees will be up over 30 hours and a certain number will be under 30 hours. Then going forward during the 2014 plan year, those employees who were over 30 hours would be covered for this entire stability period. Again, regardless of what happens with their hours on average during this stability period. Okay? Any employees during this measurement period that turn out to be below 30 hours and are not, do not need to be covered will not be covered during the stability period unless well, there's an exception. We'll talk about that in a minute, but will not be covered for the entire stability period, even if their hours increase during the stability period. And then while this stability or coverage period is going on, you're providing coverage, you're simultaneously also counting the measurement period back for the next stability period. Okay, so we have a measurement period and stability period going forward, and so forth and so on. And so each year that you are covering people under the stability period, you're also measuring for the next year's stability period. So this is how you would treat ongoing your current population as you're moving into your first sort of healthcare reform plan year. You would move into that by counting people in 2013 for 2014. And again, as we discussed last week, I think 2014 is a really great year now, given the enforcement delay, to sort of test out some theories about how you're going to count people, whether or not the look-back measurement period works for you, whether you really want to go up to the month-by-month measurement, or if you want to use the look-back. Because the penalties won't be applied, it'll give you a chance to do some measuring to bring your, whether you're going to use your payroll system or some other system for counting hours, bringing all of those systems into alignment to determine which method is best for you. But what happens if we do hire a new employee? How do we take that person into effect? Again, we've got our ongoing period, measurement period for the current population, and we were counting people and covering people. This uses the 2014-2015 years. We've been going on. We're during 2014 now. We're measuring our ongoing workforce for the 2015 plan year. But then in 2014 in June, I hire a new person. Okay, I hire someone. At that point in time, when I hire that new employee, I need to decide and I need to know whether or not that employee is being hired for a job that works on average 30 hours or more every week. If so, I give that person, I apply the waiting period that's under the plan, again, not more than 90 days, and then I put them on the plan for the remainder of the stability period. From in this case, if they were hired in June here, the remainder of the stability period would be till January of 2015, at which point they would be thrown into the ongoing population and their hours counted. But if I hire this person in June of 2014 and they're a variable hour employee, they get to have their own employee measurement period. I get to measure them for an entire year before I would determine whether or not I had to put them onto the coverage. So I'm going to count their hours and average their hours from June of 2014 until June of 2015. If they don't come up to 30 hours or more, I don't put them on the plan. I've never had to add them on the plan during the measurement period, and I don't have to put them on the plan going forward. If their hours do average over 30, then I put them on the remainder of the stability period that I'm currently in. And then at that point, they go back into the standard measurement period with everyone else. Okay, so at that point in time, when I hire someone, I need to know whether or not they're going to be working on average 30 or more hours a week or not. One of the things I've talked to some of our clients about in particular is looking at your job descriptions and making those determinations by job description at the outset. So you're doing that before you hire somebody in the middle of a measurement period if you're going to use the look-back safe harbor. That way, when you hire someone, you'll know by the job description whether or not that's someone who's going to need to be offered coverage within the waiting period and put on the plan during the current stability period, or if that's somebody that's going to work a variable hour shift and would need to be measured on their own. Now, when we looked at the definitions before, the statutes call this the initial measurement period. I call it the new employee measurement period because it's easier for me to remember that that's what it's about. But when we look at the statute, that's the initial measurement period, or a separate measurement period for each new hire. Okay, so that's sort of in a nutshell how the look-back measurement safe harbor works. Now, when you're looking at your current workforce and you're trying to decide what you want to do, one of the things you can do is sort of do a workforce analysis based on your employee population. So if you have a current population that if you have part-time people or what are called variable hour people who are working less than 30 hours a week, if you have them, if they're eligible for coverage, then you need to determine whether or not you're going to continue offering them coverage. Are you going to continue under your plan now to continue offering coverage to people who work less than 30 hours? Anybody who works less than 30 hours on average, if they go to the exchange and get a subsidy, regardless of whether your plan is affordable and regardless of whether or not you offer them coverage, there's no penalty due, because penalties are only due on employees that work on average 30 hours or more. If they're not eligible for coverage, you need to measure them to determine whether or not they will be. Even though they're working less than 30 hours, you need to measure those people's hours over the course of a measurement period to determine whether or not, because of overtime or circumstance, they coincidentally or accidentally get up to over 30 hours. Once somebody's over 30 hours, again, regardless of whether it's a job classification or it was intentional, even if it was an accident, you didn't mean for that person to work that much, even if they do, you have to offer them coverage. And so that's why you want to sort of understand your part-time population. If you don't offer coverage to part-time population, then you still have to worry about your full-time people, but you don't have to do anything with regards to counting the hours of part-time employees. Again, with new hires, are you expecting to hire people who work 30 or more hours a week? Are they going to be variable or seasonal? Are you going to offer them work that's more than 30 hours or less than 30 hours? If you're going to work more than 30 hours, you need to make sure that your waiting period, that they come on the coverage within 90 days of hire. You know, are you going to use an initial measurement period or not? So going back to the analysis that we did with the look-back measurement period, how are you going to count those employees? So starting now to look at your categories of employees, whether or not you're going to consider them full-time, whether or not you're going to cover people that work under 30 hours, those are all things that we need to be doing now in anticipation of coverage in 2014, and in particular so that during 2014 we can work through some of these questions, so when the penalties hit on January 1 of 2015, we're ready in our plans. There's some special rules that we need to make sure we're paying attention to. One of them has to do with a change in employment status. And again, if you remember on the sort of animated slideshow a few slides ago where we talked about the new employee measurement period, and I said if you hire somebody and they are a variable hour employee, you don't need to put them on the coverage because you're going to count their hours for a year. That's true. But if in the middle of that new employee measurement period that person gets promoted or has a change in employment status, something changes significantly in their job, which makes them all of a sudden now a 30-hour person, a 30 or more hours per week on average person, then they need to be put on the plan sooner than the end of their first year. So if they stay a variable hour employee and they're still working a variable shift and their employment status hasn't changed, you still count them for their own entire first year and make a decision at the end of the year based on that year's average. If, however, in the middle of that initial measurement period or new employee measurement period, they have a change in employment status, get promoted, change to a new job description where they're going to be working 30 or more hours a week, then you need to put them on the plan. You need to put them on the earlier of the first day of the 4th month following the change, or if that change happens closer to the end of that year, like in the month before the initial measurement period would be over, you'd need to put them on before that next stability period would end. And so there, we can, you know, if anybody needs some more guidance on that, that was a lot of information to put in one slide. But remember that if there is an employment status change during that initial measurement period, then you may need to put somebody on sooner than the end of that initial measurement period. So again, this is the slide I was talking about. So during this new employee measurement period, in this particular instance, let's say that here on October 1st, there's an employment status change in this variable hour employee who I had not put on the plan this entire few months because I was counting their hours to see if they would be eligible, moved into a job that is a 30-hour or more job, 30-hour or more per week job, then I would have to put them on the first of the month following 4 months. So October, November, December, January, by February 1st, I'd have to be putting them on the plan during the current stability period. Okay? So I want to make sure everybody was aware of that one caveat. There are also some special rules with regards to rehiring employees, and these get somewhat complicated. I want to go through these, though, so that you understand how these work with regards to certain employee situations, bearing in mind that when the regulations were written, these particular rules were sort of fleshed out in theory, and the tri-agency, in this case HHS, asks for specific guidance and comment on these specific situations because they were concerned that these may not work in all employment situations. And so I think these could change going forward, but I want you to understand how they've been proposed at this point in the regulations so you know how to start thinking about them. the most important of which has to do with rehired employees or employees that come back after a break in service or a service absence is the way it talks about it in the regulation. These rules would apply then to an employer that used the look-back safe harbor method, because if you were using the month-by-month method, it wouldn't matter. If somebody was off and they were on and they were off and they were on, you would go month to month to month to determine coverage. But with regards to the look-back safe harbor method, these rules are particularly important because they have to do with whether or not you are treating someone as a continuing employee, even if they're in the middle of a break in service, during that look-back measurement period, during that period that you're counting their hours of service. So the rules apply to employees who are either terminated and then rehired, or employees who have resumed work after some break in service or some absence. And they help an employer determine whether or not that person is still a full-time employee, how you're going to treat that individual. The first thing to note is that you can only treat an employee as a new employee, meaning you can only treat someone as a complete new hire and start counting their hours again if one of two tests are met. Otherwise, you have to consider them as an ongoing, continuing employee, and you have to count the hours of service based on some averaging techniques for the time that they are off work or laid off, off on a leave of absence, those sort of things. So what are those two tests? These are the two tests. The first test is if the employee's period of no service, meaning they were either terminated from employment or they were on a break in service, leave of absence, if that period of no service or no work was at least 26 consecutive weeks long, then any employee coming back can be treated as a new employee. And you can apply the new employee measurement period, you can apply a new look-back period, you can handle that individual just as you would any other new employee. You can also treat that person as a new employee if the employee's period of no service or not working was less than 26 weeks, but at least 4. So somewhere between 4 weeks and 26 weeks, you can consider them a new hire, but only if the period of employment is longer than the period of time that they're off. So if the employee worked for 3 weeks and then terminated for 10 weeks, I think I said that backwards earlier, but if the employee is off for longer than they actually worked, when they're rehired, they can be treated as new. But you can only apply the rule if the time they're off is between 4 weeks and 26 weeks long. So if the period of time that the person is absent is less than 4 weeks, say someone's off work for 3 weeks, I still have to consider them as a continuing employee. I cannot consider them as new because they weren't off for at least 4 weeks. They have to be off at least 4 weeks and less than 26 weeks, so between 4 and 25 weeks. And as long as the time they're off is longer than the time they worked, then I can consider them new. Otherwise, if one of these two tests doesn't work, then I can't consider them as a new employee. I can't start counting their hours over, and I have to count them as a continuing employee. Okay? I hope that isn't too terribly complicated. So what happens if I have to consider them a continuing employee? So if neither of those tests is satisfied and I have to treat them as an ongoing employee, the continuing employee then retains the same measurement stability periods that they were in before they left. So if somebody has a break in service or a leave of absence in the middle of a measurement period, when they come back, if I have to treat them as a continuing employee, then I am continuing to count their hours in that same measurement period. Okay, I continue to treat them either as a covered full-time employee, or I'm going to count their hours. And I have to put them back into coverage if they would have been covered in that stability period before they left. So they come back onto the plan as if they never left, unless I can meet one of those two tests, and then I can treat them as a new employee and apply the waiting period. Otherwise, they come back as a continuing employee. I cannot apply the waiting period, and I put them back into the same status. they're back on the plan in the status they were at as in that stability period, and because each stability period is also the measurement period for the next stability period, I have to know how I'm going to count hours during that break in order to determine whether or not they're eligible for the next stability period. Hope I haven't lost anybody, right? So continuing employee, they come back as if they never left. I put them back on the plan or not on the plan in the current stability period based on the status of their coverage before they left work. So if they were covered before that break in service, I put them back on as covered. If they weren't covered, when they come back on, they're still not covered. But in either event, there's this period of time between when they were, left work and when they came back, the period of quote-unquote no service, that I have to count. I have to figure out what to do, and there are two ways to do that. You can, for a continuing employee who is on a certain kind of unpaid leave, an FMLA leave, USERRA leave, jury duty, those kind of leaves, the employer has to determine the average hours of service per week for the employee, excluding the paid leave period, and then use that average as the average for the entire measurement period. So I'm going to average their hours out, excluding the unpaid leave, and that's the average I would use for the measurement period, looking back. I don't have to include any number in that unpaid leave time. Or I can credit them the hours of service that they would have worked, I believe they would have worked, in the time they were off. Either way, I have to somehow account for the time in that no service period, particularly if I am calculating a no service period for FMLA, USERRA, or jury duty. All right? No, it's very complicated. Okay, so what else is coming up? I mentioned that there were comments requested on certain segments of the regulation, including the rehired employees with the no service periods of time. There are other open questions as well. Those have to do with short-term employees. If I hire somebody just for a short-term schedule, what do I do with them? We don't have answers with regards to that at this point. Similarly, there are a lot of questions that are still unanswered with regards to high turnover jobs, how we're going to be counting those. And the biggest question of all is still the one about temporary staffing employees and whether or not those are employees of the temporary staffing agency or employees of the employer who has hired them to do the work. Under these regulations, including the look-back measurement regulations, we're using a common law employer definition. An employer that has 50 or more employees has to offer coverage to all of its 30-hour common law employees. When we talk about a common law definition of employee, we're talking about the ability of the employer to direct that employee to do the job. So if MedBen hires Bob from Account Temps to come in and do work for us, and I'm the employer telling him what to do, when to show up for work, what projects to work on, how to do them, how to use our accounting system, how to handle payroll in a certain way for us, what dress code to work, when to take lunch, then he is my common law employee and not the employee of the temporary agency of Account Temps. In that case, I would be the one that would need to be offering him coverage. IRS Revenue Ruling 7630 goes into this in some detail, particularly talking about a temporary agency specifically that trains sales clerks to do work for like Christmas retail work for certain employers, and in that case, the IRS found that these sales clerks were actually employees of the temporary staffing agency because it was the temporary staffing agency that told them how to do their job, placed them there, told them when to show up, told them what to do, how to run the cash register, what procedures to follow. So in that facts and circumstances pattern, they were employees of the temporary staffing agency. So if any of you are using temporary employees and getting them from temporary staffing agencies or at least PEOs or least employee organizations, make sure that you look at the contract and know who is directing them to do what, because they could end up being your employees for health care plan purposes. We want to make sure that we know whose employee that person is. But that's a question that's still very open-ended with regards to the regulation, and I wanted you to be aware that that's not yet been answered. These regulations that talk about the look-back measurement period and the month-by-month measurement period for that matter are still in proposed form. We've not received final regulations yet, and we don't know to what extent these might change. Again, a very good thing that 2014 gets to be sort of a practice year for us as we move into the healthcare reform, the full implementation of healthcare reform going forward. So those are my formal comments for today. We have about 10 minutes. If people want to ask questions, I will await your questions. I hope I haven't made that too confusing for anyone. Again, we're making these available on MedBen's YouTube page. I haven't actually myself gone out to see if they're there. If anyone's having trouble with those links, please let me know. We can get those out there. They will be available a couple days after each broadcast. Okay, we have questions. Okay, do personal days, vacation, or holidays count towards the hours? So yes, any standard time off, which is paid time off, count towards the hours in both the month-by-month measurement and the look-back measurement safe harbor. Any paid time off would be considered hours worked for counting purposes. It's the unpaid time and the leave of absence time for the no service periods of time that we would look at a break in service and not count the hours. Or if there was unpaid FMLA, you would have to determine how you were going to average those hours for the employee. So basically, if it's FMLA, USARA, or jury duty, you would treat it like paid time off, but you have a couple options for how you're going to average the person's hours into their whole measurement period. Any other leaves of absence, the hours that they would otherwise have worked don't get counted into their measurement period. But any paid time is going to be treated as if it were worked. So they would get the benefit of those hours in getting up to 30. Hope that makes sense. While we're waiting on some additional questions, I can do a commercial for next week. Next week we're going to talk about the insurance marketplaces or the exchanges and what your HR department will be facing with regards to the exchanges, which are coming October 1st, I'm told. It still appears that they're supposed to be in place for October 1st. We'll also talk about the exchange notices and how to comply with getting the exchange notices out and some options with regards to those notices, because I believe there are options. I don't think everyone has to use the model notice. And we'll talk about how you can approach questions that your employees may have with regards to the exchanges, and that'll be next week's topic. The week after that, we're actually going to talk about the new wellness rules a little bit of a departure from healthcare reform, but it actually will tie in because there is no departure from healthcare reform any longer. All right, so any other questions? Okay. All right, well, seeing no other questions, I think we'll go ahead and close for the day. Again, I thank you all for joining us, and please join us next week for exchanges in your HR department. Have a wonderful day.